Meanwhile, government has vehemently denied any grand scheme to oust the embattled Chief Justice Gertrude Torkornoo. Spokesperson of Government Communication Felix Kwachiofosu insists that President Mahama has followed due process as stipulated in Article 146 of the Constitution.
Every single public official, from the President to the Speaker to the Chief Justice to Supreme Court judges to ministers to all public office holders, no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play.
Deputy Ranking Member on Parliament's Energy Committee, Collins Adomako Mensah, has expressed disappointment over the looming increase in electricity tariffs. He argued that the decision lacks justification, especially in light of recent macroeconomic gains, and warned that it could further burden ordinary Ghanaians.
Dollar was performing quite well. It came down to 10%, 10 cedis per dollar. My expectation was that this will lead to a decrease, at least for the third quarter, in the tariffs on electricity. So reading this morning about an increment is quite shocking to me.
Parliament has passed a bill to redesignate July 1st as a statutory holiday. The move officially restores the day's national significance, marking a shift in the country's holiday calendar. Parliament has also removed August 4, previously observed as Founders' Day, from the list of statutory holidays. In its place, Kwame Nkrumah Memorial Day has been renamed Founders' Day and will now be celebrated on September 21st each year. There is growing tension across public university campuses as the Tertiary Education Workers Union, TEWGH, has issued a 7-day ultimatum threatening to strike over what it calls unfair decision by the Ghana Tertiary Education Commission, GTEC. TEWU Ghana is protesting a recent GTEC directive that permits a rival union, TEWU TUC, to represent non-teaching staff on the governing councils of public universities. King James Azobita is the General Secretary of TEWU TUC.
All our members were organizing them and they are going to be in council. Even where our members were not in council, the acts are here. I have got all of them here with me. And we have members in all the universities, and we'll make sure. I was laughing when he was telling me I can't appear at American University. We don't even have one member there. We have members there, and they will come to council.
It's more on 3 News. Make some time and visit 3news.com. This is Ghana Tonight. As always, brought to you by Flamingo Paint, Simply Superior, Sasso Insecticide Spray, and Qualcomm Tum Precom. Coming up next, and this is one that a number of you have been talking about. We're going to get into the full details of how things played out earlier today. The suspended Chief Justice, Her Ladyship Justice Gertrude Torkornoo, says she is tough, but she will not either ways resign nor retire. She is ready to walk the long haul and ensure that, in her view, any form of injustice is dealt with. She had strong words about the entire process that she has been involved in as enshrined in the Constitution, but here's her view. She's filed fresh court processes to seek a review at the High Court to quash the ongoing processes seeking to remove her from office. In fact, she announced that decision while breaking her silence for the first time, insisting she would not resign from her position as Chief Justice. As a matter of fact, this is an unprecedented move we saw today of a press conference by a Chief Justice suspended, going through a process as enshrined in the Constitution. She was clear in her words. Resignation is off the table. She's going to go through it to the end. Take a look.
Resigning or retiring while Article 146 proceedings are being conducted to remove a judge. is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
Well, so that's it. Very clear in her words. This call for her to resign, she said she's had some people, make that suggestion. Others are saying that she should do so, or she could face harm. And the details of whatever harm that she talked about was not put out. Well, the minister in charge of government communication was quite clear in his words. Government, essentially, the president has no interest whatsoever in this particular exercise, and he's only doing as has been enshrined in the Constitution. Let's hear from Phyllis Kwachiofosu responding specifically to some of the issues that were put out by the Chief Justice earlier today and that press conference. And we'll get into the 4 reasons why she decided to do this unprecedented. She's indicated that it was worth she speaking today. But this is Phyllis Kwachiofosu earlier today. Take a look.
Every single public official, from the president to the speaker, to the chief justice, to Supreme Court judges, to ministers, to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. That the attempts to link dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. It's regrettable and should not find space in this sort of discourse. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. She is entitled to do so, and we encourage her to avail herself of any opportunity there is to vindicate her rights.
That's Phyllis Kwachiofosu there. He is the minister in charge of government communications, also responding clearly to the suspended Chief Justice's concerns there. She indicated that the removal process is historic. And Dennis Paberi with Esquire with me in the studio. We're going to go through the 4 reasons that she put out, reason why she did this, and then also other matters relating to the details she gave today. It's good to have you, as always. Join us.
Alfred, pleasure being here.
What were the 4 reasons that the Chief Justice indicated was the reason why she addressed the press today?
Well, so let's start from the top. And it's a conversation that we've already been having. And she makes the case that the reason she's forced to come public to speak is because, in her view, this is something very significant, that it's the exercise of same should be one that could guide generations to come. Mm-hmm. She says so because she's the first Chief Justice to have been undergoing this particular process and to even be to a point where she has been suspended. And for that reason, she's saying that she's speaking out just so that Ghanaians get to know what process she's going through, because in her view, the process should have been one that would provide guidance for future occurrences and also for many to take a cue from. Unfortunately, she states that all the processes that she has been taken through is not in accordance with law, for which reason she's compelled to speak up on this particular matter.
Right.
You'd hear her speak about how some things in her view were not done and how things were not supposed to be done to him that were done to him.
I mean,
so she explains clearly that for the fact that it was a historic event and the stakes were high, much was to be expected in that exercise. It is a contention that the higher stakes, and considering the nature of the activity and what she's going through, she does not think that it is the right thing that she's going through, for which reason she's speaking up.
Right.
Now, she also talks about how far-reaching the exercise could be, considering that this borders on people who are covered under Article 146, whose removal will border on Article 146, and that will apply to other superior court justices. We're talking about Justice of the High Court, Justice of the Court of Appeal, and other Supreme Court justices, not just the Chief Justice herself. Yeah. It also extends to commissioners of independent state bodies like the EC, the SRAJ, and such, and NCC and the like. So she says that for the fact that even though she's going through this process alone, the implications are far-reaching, and it will not just apply to just her in the future.
Okay, let's get her on that one. This entire, the removal process and the far-reaching consequences, or in her view, the other persons that could be impacted in the future. Take a look.
Every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
What was the third point?
Yes, so the third point has to do with some alleged constitutional violations and illegality of the proceedings. Alfred, you would recall that all through this process, there's been at least 5 attempts to stop the process.
Yeah.
At every given stage, or on each attempt, there's always been an argument about the legality or the constitutionality of the process.
True.
The Chief Justice today is also making allegations that what she's been taken through is unconstitutional, it is illegal, and the proceedings violate the Constitution, and then to that extent, they do not deserve to proceed or even stand. And the reason she's speaking out is that she wants all Ghanaians to know what she's going through, and that what she's going through, like you heard her say in that clip, it's unconstitutional and it violates every single tenet of justice delivery that is known to the Ghanaian law.
On the matter of the secrecy of this entire process, I think she captured in there as well, no?
Yes, so when she began to expound on what the alleged constitutional violations are, she takes us back to some matters that for some reason we have come to learn, which ordinarily we should not learn, which is what has happened before this committee hearing. Remember, she's been asking for a public hearing because in her view, the petitions are already out there, her responses are out there, and it does not put the matters into proper perspective. And if that has happened, then even though there's a constitutional requirement for the proceedings to be had in camera, she would rather prefer to waive that right and have that heard in public. That's the Supreme Court did not find favor, with that argument to grant same. We'll go into that matter. But she raises other issues about even how she was entitled to get a copy of the determination of the prima facie case, which was made, for which reason all this proceeding is being conducted against her. She says that she did not have that. She raised these procedural matters as in when she appeared before the committee, how her lawyer was not even acknowledged because she was not present that day, how dates were fixed without her knowledge or without notice to her lawyer. And also, in her view, it is a procedural breach for some of the petitioners not to, or to elect not to testify, and that the committee granted same. She talks about how she herself has been searched when she's going to the venue for these hearings, and also how her family, immediate family, is not allowed to also be in attendance when she's going for the hearings, and a whole lot of other matters. But remember, these were matters that she deposed to in a supplementary affidavit when she made that application to the High Court for an injunction by the Supreme Court, based on a prayer that was made by the learned Attorney General. The Deputy Attorney General was in court that day to have that affidavit struck out, because the argument was that these were matters that had happened before the committee. And for the fact that the matters happening before the committee are supposed to be in camera, they did not have to be in public. So that affidavit in support was struck out. But if you listen to her today, the same affidavit that was struck out, or the contents of it, largely are what have been characterized in this presentation today.
Perfect point. Now, I know you're going to flip into a bit more detail, and on the matter of the secrecy, right? She talks about an agenda of a sort that she says is being pursued under the clothing of the secrecy under Article 146, specifically about this entire process. Let's take a listen to her, and then we'll flip into the detail that you have in there. Let's take a listen to the Chief Justice.
I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety.
That's her view on this entire process of the secrecy as captured in Article 146, which defines, 6 to 10 defines the entire process as we've seen playing out now. Now, we do know what the position of the Supreme Court on her demand for that public display of the entire process, which she was seeking.
Yes. So from what we know, by virtue of some of the judgments that the Supreme Court has given in respect of this matter, it doesn't appear that the Supreme Court is willing to yield up that constitutional provision allowing somebody undergoing this process to request for a public hearing. And we say so because when you look at the most recent judgment from the Supreme Court in respect of Her Ladyship's own case, the injunction application, Justice Amadou Tanko, who gave the lead judgment, in parts had this to say in reference to her request for the public hearing instead of the in-camera that's required by law.
Yeah.
He says that in advancing her preference, her here refers to Her Ladyship the Chief Justice, for a public hearing of the committee's proceedings, the applicant has failed to disclose the motivation for an invitation to this court to consciously usurp or, to say the least, ignore a constitutional prescription for her personal choice without taking into consideration the confidentiality and integrity of the process and the interest of other parties to the process. He goes on to say, in fairness to the applicant, I think she believes that publicity of the proceedings or opening same to the public will ensure her understanding of fairness of the process. But the question is, how exactly would that be achieved? Mind you, this was a ruling in which the 5 justices on the bench disagreed with her to grant that injunction application.
Yeah.
The reason this came up was one of the reasons for which she wanted that injunction granted was the fact that in the substantive suit or the writ of summons itself, she was asking for a relief in respect of this.
Right.
Even though they did not go into the substantive matter, but they had to touch in parts to explain why this could not be grounds enough for that injunction application to be granted. Now, Justice Richard Ejie Frimpong had something interesting to say. That it sounds disturbing. It sounds to me disturbing that the applicant wants the proceedings held in open, mainly by reason of alleged leakages of the petition and her responses. That the alleged leakages, whoever caused them, committed plain illegality in terms of the prevailing provisions in Article 1468, which mandates in-camera holding of all proceeding. He goes on to make the case that to stand on an illegality, to depart from what the law says, should not be upheld.
That's
the
very
extended version of this, you would have the judge liken this to a situation where that if there is a leakage in an examination, does that mean that it should be opened up for free for all copying? So clearly, when it comes to the secrecy of the proceedings, at least from this particular ruling in respect of that injunction application, it doesn't appear that the Supreme Court is willing to yield up to anybody who wants to even waive that if it were a right to you, as the Chief Justice argues strongly.
It's a very instructive point, Dennis, that you make, because the Chief Justice, before going into the details of the petitions against the three of them, she said, well, this is already in the public domain. The details of the petitions have been published on social media, so it's not as though she's going to say anything new. But based on the details of one of the judges or justices who sat on her case, the point is that to the extent that it has been leaked, it's an illegality.
Yes.
So the acting that's the suspended Chief Justice referencing this act of illegality to proceed and get into the details of the petition. How about that today?
Well, so, I mean, she didn't reference what the Supreme Court had said in this.
I am referencing.
But what she is saying is that already the matters are out there. There's nothing to cover up. Especially so when you look at it within the context of the 4 reasons for which she says that she's addressing the public. She's convinced that the whole procedure is flawed. She even used words that are even stronger than flawed.
Yeah,
but in her view, what is happening now ought not to have happened in the first place. And that's the reason for which she's speaking up.
Right.
Including wanting the public to get to know what is happening. Because in her view, again, it has far-reaching implications because she's the first person to go through this process. Whatever happens to her today would most likely happen to the others to come after her.
As unprecedented as it is. And you want to get into a bit more before I bring in Martin.
The call for the resignation and retirement. And also some alleged threats on her life.
Yeah. And I wanted to hold a brief on that because that's another big area as well. Martin Kpebo is a private legal practitioner and he's been following this case quite closely. He's joining us on Zoom right now. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
Yeah, good evening, Mr. Ocansey.
Now, listening to the detail as broken down by Dennis, and I know you followed the press conference as well earlier today, has her ladyship, the Chief Justice, done herself and her case any good by addressing the press today or Ghanaians, the nation today, and putting out this detail, which she says, in her view, it's necessary that the public gets to know how flawed, illegal, and unconstitutional the process she's being subjected to is. Has it done any good for her?
Mr. Ocansey, that's $1 million question. To be honest, it's a mixed bag. You can imagine that for her supporters, certainly this would ginger them up, right? And for those who may not support the case, this will not endear her to them. So it's a mixed bag. The jury is still out there, right? Yes. But what we can be certain about is that she's come out with a lot more details than the Supreme Court has given allows. Because the Supreme Court, through its various decisions, has made clear that we should not leak the contents of the petitions, one. We should not bring out or leak or disclose the happenings in terms of the proceedings whilst they are ongoing, etc. But you see that in the interview, she's brought out a lot, far beyond what the Supreme Court has sanctioned. That much we are very sure of. But as to how good it has done to her case, the jury is still out there.
And that particular reference you make about the Supreme Court position on going into the merits of this case, she did it today. In fact, referencing all three details of the petitions and read her responses to them as well, publicly. Would you say that in doing so, she potentially has gotten herself into some contemptuous act, an act of contempt?
Absolutely. She's bordering in that area, okay? Yes, what she's done is bordering in that area, and the word I'm using is bordering because, or as you have used the other word, potentially, because, you know, a person is innocent until proven guilty, right? And we use that principle in contempt cases, even though contempt is not a criminal matter. Some contempts are criminal. Those ones, they are in the Act 29, right? But other contempts who are civil. But whether it is a criminal contempt or civil contempt, we still use the same criminal standard that you have to prove beyond reasonable doubt. We don't have that. We don't have enough evidence. But at least what we are saying is that on the face of it, she's given a lot more details than the Supreme Court has sanctioned. So in the Justice Derry case, and it's good, this afternoon, an earlier interview with you would make a good lawyer someday. You know, you raised the matter of contempt. I didn't quite get it, but let's just say, put succinctly this way. Yes, we are talking about contempt, but it is not the committee that has the powers of contempt. No, the committee doesn't have. So if the committee feels these are contemptuous, then the committee has to refer the matter to the High Court. That's the difference. So when we mention contempt, then quickly we have to add that the committee has no powers of contempt. And so if there's any section in the Justice Paul Derry versus Tiger IPI case, the Supreme Court held that such matters be referred to the High Court, then the High Court will deal with the contempt application. It's not only the committee that has to refer its cases to the High Court. Also in our laws, when you are going for arbitration, when you go to arbitration and then you do something that border on contempt under the...
Unfortunate. Sorry. Lawyer Martin Pebo, we lost him there. We'll try to get him back on Zoom. He was making a point there. We'll seek a conclusion to. But we also have Kweku Asasari, a former director of the Ghana School of Law, joining us on the telephone. Appreciate your time, sir. And I'll backtrack to that first question that I posed to Lawyer Martin Pebo as well. Hearing her leadership Chief Justice earlier today, an unprecedented move, addressing the nation on an ongoing process, which she says, in her view, the public must know how flawed and unconstitutional, illegal this process is, and in her view is skewed towards her disadvantage, and so people must know what's going on. Has it done any good for her?
I mean, it is an established intent. Sir. No, the wrong approach. I don't think that this is the first time, that we are witnessing in a purported removal of a Chief Justice. This thing started, way back in 1950 or so, soon after independence and then, the Republic. And, we have the likes of Sir Kosa and Sir Diado. And therefore, I mean, to say that she's, sounding a caveat or warning, that, Ghanaians must share in this, it's too late, in the day. I think that I share, frustrations with her, but, the path he has chosen is not the right one. The approach is totally wrong. The committee probing the allegations was established by the president. If she has any misgivings, she must address her concerns to the president. Now that the committee is working, she cannot appear in the court of public opinion today and then next day find herself before, the committee established to go into, the allegations of impropriety against her. I think the two, cannot coexist. And being the head of the arm that watches over the justice delivery system, she must be the last person to express disfavor with the judicial process, to express a loss of confidence in the judicial process, to express frustrations, about the justice delivery system. It is, politically wrong, judicially wrong, legislatively wrong, and the fourth estate wrong. He's gotten it all wrong.
And it's interesting to take this position as well, and talking about this decision by her being constitutionally wrong and legally wrong in your view, and in the fourth estate as well wrong. And Dennis is still with me as we proceed into the other aspects that she put out today about some threat on her life. Exactly what was the context of the threats that she talks about, Dennis?
Well, so that had to do with the calls on her, as she put it, for her to either resign or retire in the face of what all that is going on. She says that loved ones and people who are concerned are actually concerned that she's going through all this process, which she seemed to have issues with. And the police calls to her, urging her to either resign or retire just to end it all. She explains why that should not happen. So let's just listen to her, then we'll come back to the conversation.
Persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started.
Well, Martin Pebo is back on Zoom. Council, we lost you briefly. If you can hear me, thank you for reconnecting. Now, on the back of what Her Ladyship, the Chief Justice, just indicated about the threats that she had received and the fact that the calls on her to resign, or she could possibly be exposing herself to some threat. I recall you had made that suggestion to her right from the beginning of this entire process, that she should just resign. She says that is not on the table. It's not an option that can even be considered, and that at the great disadvantage and discomfort to her, she's going to have to marshal all her arsenals and ensure that this entire process goes way through to the end. Counsel.
Yes, yes, the point that it's not open to her to resign is correct in law. Yes, so this is one that on the program, see that I was in favor of the resignation because I thought it would favor the whole, or it would be beneficial to the justice system and the larger Ghanaian society because it would have brought closure quickly, etc. But subsequently, turned out there was a Supreme Court decision my attention had not been drawn to. That's the Justice Amwa case. And then later, I saw that in the Justice Paul Derry versus Tiger PI case, that one to the Supreme Court repeated that when the processes start, it's not open to the respondent, as the person that's answering and has been accused of wrongdoing, to resign, right? Yes, so that's what the Supreme Court says. But, you know, and that's the Supreme Court is the final arbiter on the law, except that, you know, the law too grows. The law grows. If you look at the way, you know, this whole trial is panning out, the way Chief Justice Tokono is come out and describe what's happening. I'm not saying that everything she's said is true. I'm not in a position to judge, but I mean the fact that she's describing to us what's going on in there, etc., and the previous, you know, leakages, etc. Then you see that this reinforces the opportunity for a resignation because it helps us. So these Supreme Court decisions, let's see. You know, the Supreme Court has an opportunity to depart from its previous decisions. I'm not saying that in this particular case is going to do so, but, you know, it's powers that are in the Constitution, sometimes looking at the damage, etc. The Supreme Court can look at it and with hindsight try to correct. Because I'm sure at the time we're looking at, or the time the Justice Amwa decision was given, that's in 2015. That's a 2015 decision. Then you come to the Justice Derry one. The Justice Derry one is in the 2015-2016 Supreme Court of Ghana Law Reports, right? That's volume 2. Yes. Right. At that time, nobody contemplated what is happening now, that a Chief Justice would come out and seek to tell her version. So let's look at it. Going forward, somebody could take it up. But for now, on the authorities, they say that once the process has begun, then the respondent, that's the person who is accused of wrongdoing in the Article 146 proceedings, cannot resign. And this one is not applicable to only Chief Justice Tokono. It also means if, let's say, the electoral commissioner were in a trial today, or take the other constitutional bodies, also you have Court of Appeal judges, High Court judges, the OSP, and the NCC. So all the officers who are entitled or who must go through Article 146 proceedings before they can be removed have the same law. That's all of them go through 146.
I see. And Counsel, maybe quickly before I let you go, having described the entire process, the committee, some of the members of this committee, and the entire work of the committee in these words, as you heard her at that press conference earlier today, would you say it would be to her good to go back and still continue the hearing before this same committee? Or at this point, after this press conference, walk away?
Most probably, if she continued to participate, it would help to ameliorate, that's reduce the damage that will be done to her case, right? If she didn't participate at all. So let's take it this way. Some allegations have been made. It is through cross-examination of the witnesses for the petitioners, etc., that we will get a clearer picture. And also, so generally, you know, sometimes there is bias. So as you're writing the story, there are mistakes. There's also the unconscious bias. So sometimes we embellish cases more than we should unintentionally. So there's unconscious bias that you may not be aware of. So in the zeal, you overstate a case, etc. So through cross-examination, some of these things are taken out. Look, if you want a practical example, remember the National Service Authority case. When the case broke last year, just before the elections, the figures that were mentioned were far higher than the 548 the Attorney General, Dr. Ayeni, is taking to court. So these things happen. So if Justice Tokonu stayed, should be able to reduce the impact of the cases, will be able to help, eliminate the mistakes or curb mistakes, etc. Then we'll get a truer version than if she just abandoned it. So it's definitely in her interest to continue to participate. But there's a part, I don't know if you've already referred to it. Mm-hmm. She said she'll be going to the High Court to challenge some of the unconstitutional actions, etc., that she's seen. Yes. So let her have a day in court. Then we'll see how it pans out.
I appreciate your thoughts on this, Counsel. Thank you very much for your time on this. We have still more days ahead of us to get into a bit more detail of what she put out earlier today. Martin Bebo is private legal practitioner. And Dennis, on that last point about what she's going to do next and what she's instructed her lawyers to do, that's the next phase and the final phase, is it not?
Yes, so she's now heading to the High Court. And in that action, she intends to, in fact, she has indicated that lawyers have filed for a judicial review of all the processes that are ongoing before the committee. Now, many are asking, if you have gone to the Supreme Court, why are you coming back to the High Court? Now, the one at the Supreme Court was in respect of a constitutional matter, where she was seeking an interpretation. Based on that, she filed an injunction. Now, going to the High Court is an administrative matter, where she's seeking to quash the processes that are ongoing before the committee. So, basically, that's the next line of action for her. But mind you, her case is still pending. The substantive matter itself at the Supreme Court is still pending. Not much has been heard about it. But yes, the fresh step that we are learning today is the fact that she's now before the High Court for judicial review in respect of the same processes that she's contending.
Perfect point. Dennis Pobero, I appreciate you, as always, breaking the matters down for us.
Lawyer who spoke, prophesy into your life. You want to be a good lawyer.
Just as you have inspired me to do.
Thank you.
Absolutely. This is the suspended Chief Justice talking about the process or what next she intends to do going forward. Take a look.
It's this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file application for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47,
Well, that's the suspended Chief Justice there. And this, you can find more details of it on 3news.com. Coming up next, the Office of the Special Prosecutor is pursuing suspects in the infamous SML GRA scandal, making significant arrests as investigations continue. We've got updates and details for you here on Ghana Tonight. And these individuals, and right after this quick break, we'll get into a conversation with Edem Senano. But these individuals, also a special prosecutor, arrested Reverend Dr. Amishadai Owusu Amoa, former GRA, that is. And then also we have here, from what we got to know, the former commissioner of the Ghana Revenue Authority, this man, and he was arrested yesterday together with this gentleman as well, Christian Tetesoti, the last man, and the former technical director and advisor, and now MD of the SML. Now, these three gentlemen, we understand, spent the night, last night, in the coolest of the OSP. But there was a development today. They're not the only ones who have been arrested as we speak, and some granted bail. There are 5 other individuals who were arrested earlier today by the special prosecutor. Ivan Seduse, who is the CEO of SML, Philip Mensah, former Deputy Commissioner, Legal of the Ghana Revenue Authority, and guess what? He is also now legal consultant to SML. Kofi Nti, former Commissioner General of the Ghana Revenue Authority, and Joseph Kruk, Public Procurement Authority official, together with Faustina Ajoko as well, who works with the Public Procurement Authority. Now, after this quick break, we'll tell you why this is happening. And you'll recall that the former finance minister, this GRA SML deal It's one of 5 issues why he's wanted by the OSP. Stay with us. We'll be back shortly.
Why are more and more professionals
Welcome back. This is Ghana Tonight. As we're getting to the last lap, we set the basis for this conversation on this GRA-SML deal. You recall this KPMG report. The full complement of it is not out in the public domain as yet, but this is what they put out last year. And first off, that this entire SML deal, one, did not have any needs assessment done before it was awarded, and then also there was, based on the details of the KPMG report, there was no approval by the Public Procurement Authority. And then also the GRA board itself did not even consider and approve this SML deal before it was executed. And then in terms of revenue to the state, the KPMG report found out that no deduction of VAT by GRA for an 8-month period on the payments made to SML, which led to some 13.838 million cedis lost to the state. Apart from that, they talk about all of these laws that they believe that the portions of this GRA-SML deal has violated. The 1992 Constitution, Ghana Revenue Authority Act, Public Financial Management, Public Procurement Act, National Petroleum Authority Act, National Petroleum Authority Regulations 2012, Value Added Tax Act 2013, Public Financial Management on Revenue Regulations, Petroleum Commission Act, Minerals Commission Act, Precious Minerals Marketing Company Act, Ghana Standards Authority Act. All of these laws, according to the KPMG report, the GRA-SML deal has violated a number of portions of these laws as captured in there. 8 people have been arrested, some granted bail by the special prosecutor, and these 8 people include former former commissioner generals of the GRA and 1 former deputy commissioner of the GRA, who is also acting as one of the top officials of SML as we speak. Mensano is a co-chair of the Citizens Movement Against Corruption. Adam Senano is joining us on Zoom. Thank you for joining us. First of all, I want to find out from you what you make of this development with the arrest of these persons by the special prosecutor.
Well, evidently the OSP would not be picking up these persons on the back of having done those searches a week or so ago if they didn't have very good reason to believe that they have some substantive information or they are persons embroiled in this matter, and so they needed to be, picked up. I am, in my mind, it's still part of the investigative phase, and it's good to know that these issues are not just being dropped or swept under the carpet. It's just sometimes, distressing when persons of a certain caliber appear to be involved in these things, and you are hopeful that perhaps it is not the case that they are substantively involved in, engaging in acts that are corrupt and otherwise. So we'll see how this turns out. But clearly, the most important thing is that the OSP is continuing to do the investigations, and hopefully at some point report back to the good people of this country on their findings.
And if you look at the evolution of this SML deal, GRA extended this contract with the SML, and SML then transitioned from being a co-contractor to become the main contractor of GRA. And this was without public procurement approval, without parliamentary approval, without the GRA board's approval. And there was no deduction of VAT, so the state lost revenue. With all of these violations, what does it point to clearly in terms of the persons who could have allegedly collaborated and corroborated this entire process?
Well, yes, there appears to be a conflict of interests written all over this. So the whole ethics of, on one hand, having contracts that hadn't gone through due process, requests had been made, PPA refused, they hadn't gotten the parliamentary approvals, and yet they went ahead. Meanwhile, they had all the professional skills, you have the procurement experts, you had the legal people. How could all of this happen? And then you have the transition of persons who were themselves members of GRA at one point, then transitioning to become key members in the service provider to GRA. It's just, unbelievable. So, yeah, clearly the conflict of interests is branded all over this, and why persons of such high standing would not identify this and ensure that they did not get themselves into such a situation. Mind you, the position of our constitution and most places is that you should not even put yourself into a state or position of potential conflict of interest. Public officers are supposed to be mindful not to get themselves into a situation of likely conflict of interest. So we are not even saying conflict of interest itself. The potential of it, you're supposed to be aware enough to avoid it. And so, yes, there's a lot of questions to be answered from the perspective of public officers who ought to have known better.
I thank you. Thank you very much, Adam Sodanu, the co-chair of the Citizens Movement Against Corruption. Thank you for your thoughts on this. And before we go, Parliament has passed the Public Holidays and Commemorative Days Amendment Bill 2025 to make major changes to Ghana's holidays calendar. So the new legislation will make July 1, a few days away from now, a statutory public holiday and restore that controversial Founders' Day with an apostrophe after the S. That's a Founders' Day. So Christian Yale was in Parliament earlier today, and he put together this report. Take a look.
Long hours of debate and heated exchanges, Parliament has passed the Public Holidays and Commemorative Days Amendment Bill 2025 to make changes to Ghana's holiday structure. According to the Defense and Interior Committee's report, the new move is part of effort to ensure that the holidays are inclusive, historically accurate, and reflect productivity across the country. As part of the new law, July 1st will now be recognized as a public holiday as the Republic Day. Government has also removed August 4th from the holiday structure and has now renamed September 21st from Kwame Nkrumah Memorial Day to Founders Day.
We know that there's no way you can say you go to a fight and you say you carry the fight alone. You may have other commanders, other generals, but the main person who leads you usually will take the credit for all of you. Ghanaians are unanimous around the 21st September, which is the birthday of Osadifo Dr. Kwame Nkrumah.
This process was, however, not without debate, as the minority insists the government has decided to conveniently pursue amending holidays instead of fulfilling their campaign promises on urgent matters such as LGBTQ plus activities, as well as illegal mining, and even their flagship project of the 24-hour economy policy.
That is why I'm saying that they've made promises on other bills they consider urgent. And I am wondering why those have not been prioritized. Where is the bill on 24-hour economy? The Minister of Interior has not come here with a bill to introduce reforms under the various agencies under his ministry. Or he comes under certificate of agency, holiday. Stay at home, don't go to work. This is the agency.
As part of the new law, government is seeking to introduce an extra holiday for Muslims named as Shak Day, which will be observed a day after Eid al-Fitr.
Yes, Dr. Nkrumah played his role. Every Ghanaian is so grateful. And so are men like Akwaje, J.B. Dankwa, Oforiata, and the rest. They also played a role. Are we going to come back to this chamber when the tables turn to change the day again?
The law provides that when a holiday falls on a Tuesday, a Wednesday, or a Thursday, the president may use an executive instrument to move that holiday to the Friday of the same week.
If a holiday falls in the middle of the week, that is Tuesday, Wednesday or Thursday, it should be observed on a Friday. If it falls on Saturday and Sunday, it should be observed on Monday, so that there will be some certainty, and that gives us longevity in the weekend. That will enhance our tourism industry and the Creative Act.
Once assented into law by the president, Ghana will have 14 recognized public holidays with only one commemorative day. Christian Yale, TV3 News, Parliament.
Well, there's more of this on 3news.com. On behalf of the rest of the team, we say thank you so much for staying with us here on Ghana Tonight. Join us same time tomorrow for another conversation. My name is Alfred. Ocansey. Have a good night.
Ghana Tonight is brought to you by Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil.